The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, this morning we'll begin with the case of Alig versus Rocket Mortgage, and Mr. Jay, we'll hear from you.
Good morning, Your Honors. May it please the Court, William Jay for the appellants. The Supreme Court has sent this case back for reconsideration in light of TransUnion, and we submit there are three aspects of TransUnion that require the conclusion that the district court should not have certified the class, and the class certification order must be reversed. First aspect of TransUnion I want to point the Court to is
Maybe you could lift the mic up there. Is that...
Oh, I'm sorry. Can I do that? Is that better?
Oh, that's terrific.
Great. Thank you. They tell you never to touch the microphone. So the first aspect of TransUnion I'd like to point the Court to is the holding about unrealized risk. Unrealized risk of harm is not a constitutionally cognizable injury in a suit for damages. This, of course, is a suit for damages, and we submit that the only way that this court, which this court certified the class, was in reliance on the risk, the exposure to the borrower's estimate of value. That's the first aspect of TransUnion. The second, which is related, that I'd like to point the Court to, is the point in TransUnion about the fact that after judgment has been entered awarding statutory penalties to a plaintiff class, it's not sufficient to rely on speculation or inference about whether the plaintiffs may have had standing. That has to be supported by actual evidence in the record. And that is lacking here because there is no evidence of harm to any of the unnamed class members who didn't pursue actual damages.
Well, let me ask you this. I've been trying to figure out, since that opinion came down, I don't think I have it figured out yet. We bottomed that opinion on the fact that they paid $350 for an appraisal that was, let's just say, fraudulent. And it would appear that that might not be enough. So the question is, do we have to go to the point of looking at the class, which would include only those people who were underwater?
So I think that you've put your finger right on the point that the question is, what besides the payment of $350 would an individual plaintiff or a plaintiff class have to prove? And I think that there are two different answers. So an individual plaintiff might well come into court and say that entering into this loan into which I was induced caused me some harm by, for example, putting me underwater. That could be one way of showing that in an individual case. But the plaintiffs here didn't try to show that because this is a class action, and they want to show it by class-wide evidence. So I don't think that you could show by class-wide evidence on these facts that all the borrowers were underwater, particularly because the record shows that they weren't. I mean, all of the information about how much the value was and how much the loan was, that's all in the record. And you can see that there were borrowers who borrowed as little as $13,000, $25,000 against whichever value you choose, whether the estimate of value or the appraiser's final value, of $200,000, $300,000.
My question would be then, the class could be composed of borrowers who can show they were underwater.
I don't think that it could, but the plaintiffs, I guess, could try to give some explanation of how they could show that by common evidence, but the class definition doesn't require that. So the class that the district court certified doesn't require that. And I think it would be incumbent on the plaintiffs to show how they could show that underwater aspect by common evidence. Because remember that the district court said that the standing of the unnamed parties did not matter. And so he did not look at it at all. He did not look at it at certification, and he did not look at it at decertification. So, I think it's the right question to ask, what kind of evidence would it take to show that a plaintiff has standing in this case? But I think it really is inherently individualized evidence. That evidence that you're positing, evidence that a loan, inducement into a loan put a borrower underwater, those are very individualized facts. But I think that there's a second component to it as well. Remember that this court said in its opinion that the record was devoid of evidence about whether any of the unnamed class members' appraisals were inaccurate. And so even if the borrower were to come in and claim that they were underwater, if the appraisal was accurate, then they've suffered no harm. And I think one key evidentiary point that I want to point the court to is the fact that not all of the appraisers even saw the borrower's estimate of value. And
So you're saying we should send it back so that evidence can possibly be developed by the plaintiffs?
so we obviously,
That would be the best, seems to be the best course of action rather than we speculate. You're saying these additional plaintiffs, there's no evidence as to the injury there because this court essentially looked at the named plaintiff here for it. But so you're saying send it back for, and this is a standing question for the most part, is it not?
it's a class certification question. It's not a question about the court's jurisdiction.
Focus on the standing, at least in terms of my perception of what's going on here. It's something really we didn't get too much of in the first opinion. Neither party really got into it. I'm not sure much was gotten into it before the Supreme Court, the TransUnion came down. It seems to be something that's before us now. It's a question of standing. We determined there was a pocketbook injury. Law on pocketbook injury is pretty much the same. So the question that really comes up is, did TransUnion, which dealt with a reputational type injury, impact this case that deals with an economic type injury?
It did, Your Honor. And
I understand your position is it did, and I probably should say, I know you believe that, but isn't there a differentiation when you're looking at that kind of a situation, particularly when you're looking at, you're looking at a situation where the judge, if we accept it as a class certification, someone who is similarly situated to the plaintiffs, and if the plaintiff can establish, the named plaintiff establish, which I think the record evidence does show, there's a differential in those appraisals with them. It's just you don't have it with the rest. But that's the reason these people are on. It seems part of the class certification is to say, yeah, you're just like this person here that has been injured. Not some hypothetical, well, we don't even know if they're like this. They say we're like this here. And that's the basis of class certification. If you're not in that class, then those people need to be excluded.
So the class definition is everyone who had a refinance loan in West Virginia during the right period of time and on whose appraisal order form the borrower's estimate of value appeared. So that's a very broad certification because it includes people whose appraisals were accurate. It includes people whose appraisers didn't even personally see the borrower's estimate of value when they went out to do the appraisal.
So is the remedy then to exclude those who do not fit within the more specific definition of those who can show that differential?
So I think that you'd have to reverse the certification as it currently stands, and then the question would be, do the plaintiffs get another chance to show how they could prove what Your Honor is positing? How would you prove that by common evidence?
You need to ensure that every possible member of a class belongs in that certified class in order to, if you find one that doesn't fit, do you get rid of the whole class and say, or do you simply say that individual does not belong in the class?
So remember that in TransUnion, Your Honor, so the court affirmed that the named plaintiff had standing to pursue all of the claims at issue, and yet the court said that because there were a large number of uninjured people in the class, they couldn't just rely on the fact that the named plaintiff had standing and that they were, through the typicality injury.
But could they? Could they have said, well, there may be a large number who are not in the class, then go back and exclude those who do not belong to the class?
So I don't think that can be done just after the fact. Our friends on the other side cited a First Circuit decision about economic injury. And what that case says, and what I think the consensus in the courts of appeals is that at a minimum, before you enter judgment in a certified class action, there has to be some way of excluding the people from the class who don't have standing. And where that inquiry...
I see where you're going with it, but I want to ask this. How are you going to get a class action if you got to go through every one of them and determine individually this? I mean, I understand TransUnion, where it's going at, but again, it's a reputational injury type case. But I'm wondering, what is the purpose of a class action when you can prove there are these facts? I mean, they did give these estimates. You did have this going on. All this is there. And at this point, to go summary judgment, there's not even an issue of fact that they say exists, but it could be an issue of fact as to whether it exists. But how do you get a class certification if you have to track down everyone that's in the class and say, you have a cognizable injury, and therefore you are part of the class?
So in many class actions, it will be possible to prove injury on a class-wide basis. Under this statute, so remember, this statute allows for claimants to come in and prove their actual damages, so that's one option. Another on an individual basis. I do think it would be hard to certify a class on the theory that the plaintiffs have espoused, because remember that their theory is that the mere exposure to the borrower's estimate of value, without proving that they were underwater, without proving that the loan terms had anything unconscionable about them, and without even proving that the appraisals were inaccurate or that the appraiser actually saw the borrower's estimate. All of those things don't exclude anyone from the class on the theory that the plaintiffs have espoused. So in other words, they persuaded the district court to certify a very broad class, and because they were doing summary judgment at the same time, they very consciously did not put in evidence of individual injury that would interfere with their ability to certify a class. That's a choice that they made. We don't know what theory they might come up with for how they could show injury by class-wide evidence. I do think it would be difficult.
Well, go back to the question whether you can exclude certain ones. And it seems to me, when you previously argued, I'm not sure you had a problem with that they could be excluded. Now you say maybe there is. But would you say the trial judge would have that discretion if the trial judge determined, I don't need to decertify this class, I can determine that those individuals who fit within this are now part of the class? In other words, he redefines the class. He doesn't decertify it. He says, this class is a class of people who are just like these plaintiffs. They have this evidence here and only those people are part of the class. Can he do that?
I don't think he could do that at this stage, but so
what does this stage have to do with it? I mean, we're in new law territory, aren't we?
Well, this stage, we're on final judgment where he's awarded a money judgment on the basis of the class certification that he's entered. So I think that if this court were to set that aside and send it back for further proceedings. I'm
I guess I'm sort of going there with you. I see where you're going. You're saying he would it would have to, there's a theory, this court could go back and find every last one of these class members, in fact, do, because I don't know if there's evidence they don't. It's just that there's nothing in evidence. So if they all do, there's no need to do anything, the award stands. If they don't, then he can reevaluate the award that's given based upon his assessment of what the class now looks like.
So I agree with some of what Your Honor said, but here's the qualification that I have, right? Because in order for the judge to do the work that you're positing, I think the comparison that he'd have to do involves 3,000 comparisons.
Well, that's what district court judges do. They deal with some pretty complex cases, and this is not the biggest class that's ever been made. I mean, it may be 3,000, but there are a lot of classes out there that are mass tort areas that are way beyond. And I'm not saying how it would be done or what it would be. It may well be the judge could say, if you want to be a part of this class, then you have to indicate this. But anyone who's a part of the class, if their damages are awarded to it and it's proven you're not part of the class, then you don't get it.
But so the burden, of course, is on the plaintiffs to establish that the common issues are going to predominate, that individual issues aren't going to predominate over the common ones in a class action. That's their burden. And the only way to find who's got standing and who doesn't is 3,000 mini trials about the retrospective value of an appraisal between 2004 and 2009, whether it was right.
At least from my perspective, it doesn't seem like to me you need a trial to determine that. That's an issue of fact. That's either there or not. You either can show that or you cannot. But let me ask you this. At the end of the day, if you're not in federal court, aren't you back in state court?
We're not, Your Honor, and there are two important reasons for that. One, the ALIGs have standing because they claimed actual damages. And two, remember, the whole case is removed. It had a whole bunch of counts in it. Some of those counts, standing is not contested, and final judgment has been entered in our favor. So there's no doubt that the federal courts had jurisdiction over this controversy on the date when it was removed.
Well, that's the whole part about it. I mean, there's a state statute says, you know, if you take it here and you don't succeed here, you can come back there. There's a saving clause or something there. And the whole business of whether there's federal standing, we said no, is back in state court. Why is it not?
It's not, Your Honor, because what you're referring to, the statute says if at any time it appears the court lacks subject matter jurisdiction, then the case is remanded. This is one claim, right? It's a couple claims, but in like a 9-count complaint, the standing to pursue the the claim about delivery charges and things like that, that's uncontested, and final judgment has been entered in my client's favor in that court.
Either way, the state court will determine that.
No, respectfully, no, Your Honor.
We as a federal court can tell the state court, you may not now take this matter?
The federal courts have subject matter jurisdiction, so there's no basis to remand. The reason that the federal courts have subject matter jurisdiction is that the ALIGs have standing. The ALIGs had standing to pursue the other counts, and we're not challenging.
Let me ask you about that. You're saying the ALIGs have standing?
So the ALIGs had a claim for actual damages. And
what is their damage? What would have happened if let's assume the appraisals were inflated by undue influence, which is the allegation. Let's assume that the appraisals were 1/2 what they were. In other words, each house was appraised to be $100,000 for the two plaintiffs.
Mm-hmm. Instead of $200,000. So they'd have to prove not just that the appraisal was inaccurate, but that they were harmed by entering into the loan.
Well, that's my point. In other words, if the lender goes ahead and makes a loan despite the appraiser at $100,000, so the question is, regardless of the alleged taint, they got the loan. And the loan was determined by the lender. And so the question is, they paid for the appraisal as a necessary part of the transaction as demanded by the lender. No lender can lend money these days without an appraisal. And of course, most of these are bundled into, and they have to have that part of it. But the appraisal is not for the benefit of the borrower. The appraisal's, except to the extent the loan goes through. But if the lender's willing to make the loan, my question is, you said sort of casually the plaintiffs, the named plaintiffs, have standing. I can't quite figure out why you say that under TransUnion.
So we're saying that they had standing when the case was removed because they were claiming that not only did they...
I'm talking about now, standing, jurisdictional standing. Why do they have standing?
They pursued a small claim for actual damages, which has been resolved by stipulation. And there were three other members of the class also, after the certification, had the opportunity to come forward and say that they too were pursuing claims for actual damages, and those were resolved by stipulation.
But the damages alleged in this case are the payment of the appraisal fees, nothing else.
That's not true as to the ALIGs. The ALIGs wanted more than that. The ALIGs claimed harm from the loan itself.
That's what's claimed in the briefs, and that's what's on this claim that's before us. We're trying to figure out whether TransUnion affects this. And in order for TransUnion to affect this, the question is, what's the nature of this claim? And everybody seems to concede in the briefs it's a money damage claim, that the injury is represented by the money damages in terms of $400-some for one and $200-some for the other. For the payment of the appraisal fee, nothing else is claimed. Well, now, my question is, do you concede that's standing?
No. The ALIGs have an individual claim that they're not trying to base the class on. In other words, they're not saying we have actual damages.
Let's focus on the TransUnion issue, please.
Right, so their claim for statutory penalties is based on the idea that the $350 that on average...
They didn't pay $350. One paid for something.
That's right.
I'm talking about the two plaintiffs, because we got to get by the two plaintiffs.
That's not injury.
After you get by that, TransUnion said you have to look at each individual class member to see whether the person has standing. That's jurisdictional. It says, and standing is not dispensed in gross. Rather, plaintiffs must demonstrate standing for each claim that they press and for each form of relief that they seek, for example, injunctive relief and damages.
That's right.
Now, that's the burden that when they're addressing the class action. I'm setting that aside. Now, I'm not talking about the class action issue. I think what the Supreme Court was troubled by is whether the A-Leagues have standing.
So I think that respectfully,
A-Leagues and was it Shays?
the Shays. So there are two different, they're trying to make two different arguments in this case. So they got a class certified based on the idea that just paying the appraisal fee.
Can you set aside the class action? I'm not talking about, we have to talk about the individual claims in order to measure the class. So if the plaintiffs don't have claims, the class ends. You can't represent them. So you start with the A-Leagues and the Shays and tell me why they have standing.
So so this is not in the record. All that's in the record about their actual damages claim is that it was resolved by stipulation, and that's why I'm having a harder time answering your question.
Well,
but it is not. It's not based on the. It's not based on the appraisal
says
fee.
their whole claim is for their justification for their claim is the payment of the fees for the appraisal.
That's the
now,
only.
If that's the basis of the claim, is there standing?
That would not be enough for standing. No, and that really is our point.
You're blurring a lot of arguments, and I don't think. All right.
Well, can I just clarify that point just briefly? The on average $350 is what they're trying to base the class-wide standing on.
But you have to start with the plaintiffs.
You do.
If the plaintiffs don't belong in the suit, you throw it out. And the class members, they have not even attempted to prove as to each class member the standing.
That's right.
That has not been proved. So the question is to start with the plaintiffs. They have made a claim, and their claim is I was injured by paying for an appraisal fee that was tainted, and my damages are the amount I paid for the appraisal fee. That's their claim, and they made it pretty clearly in their brief.
You can ask my friend whether that's the extent of their claim, but as
I've read it in their brief. I just want you to answer it. I'm surprised you're not taking advantage of it.
that's not a basis for, that is not a sufficient basis for standing, and that is what we've said in our briefs. What you're asking.
Is that the issue in the case?
It's not, respectfully, Your Honor, because the issue is not whether the federal courts have jurisdiction over the case. The question is whether the district court's class certification should ignore the fact that standing would be an issue that would predominate, because there are so many members of the class whose standing have to be inquired into.
You don't have jurisdiction over the case, it goes back to the state court.
Again, no,
Where you want to go with this?
it is not, Your Honor, because there are 8 other counts in this complaint.
Let me ask you about the state. If they were to bring an action now, or a plaintiff now in state court, can you do as you did then, remove it to federal court knowing that standing doesn't exist?
So if there were a 1-count complaint.
I'm asking, same case is filed now. Could you remove this case to federal court?
Well, you're asking me to assume away an important point, which is the other counts in this complaint.
Don't assume anything. Take this case. This case is starting right now in state court just like it did. You're the one that asked it to come to state court.
That's right.
The plaintiffs objected. The court wanted to send it back to state court. You're the one that objected, and ultimately we vacated, so okay, keep it here. We didn't get into the standing thing. My question is simple. If we were at point 1, where the case was in state court, could you remove this case to federal court?
Yes.
And why, knowing there is no standing?
So there are all the other counts on which standing, I think, is indisputable, the counts on which we won on the merits.
Is the 1 count.
Okay, that wasn't what I took this question to be, so I'm sorry about that. So on the 1 count, so then the question would be, do the A-Leagues themselves have standing on grounds that are not common to the class? So if they're not making arguments for their own standing, that, in other words, if they said they had no actual damages and their only theory is that we paid for the appraisal, then they wouldn't have standing, and that wouldn't belong in federal court.
In the state court either.
As I understand West Virginia's...
The question was whether you could remove it, and your answer should be the case wouldn't need to be removed. You just file a motion to dismiss for lack of standing in the state court.
I think that's right, because West Virginia has this...
Because of the West Virginia statute that goes against this federal statute in terms of the federal determination here of whether standing exists.
So as I understand it, West Virginia has a similar concept of standing to Article 3, and so Judge Niemeyer is right that when plaintiffs file a suit in West Virginia state court without standing, you can move on that basis. But
so then you would win in state court, you're saying?
If the ALIGs, it would depend on what the ALIGs were arguing, right? That's really a question for my friend. But they had a claim for actual damages, which is what makes them unlike the rest of the class, because and there's another point as well, right? They at least actually claim that their appraisal was inaccurate. They submitted a retrospective appraisal.
How's that a damage?
It's not enough, but it's a start, right? It's not enough, but it's a start.
No, how's it any claim? That appraisal is not their baby. They did not order an appraisal for their own benefit. They ordered it because they were told they had to do it and the bank wanted it.
Right, and this really...
So the question is, if you made that same claim in the state court, I understand. We're way over time and we're through the red light, and you can handle the rest on rebuttal.
Thank you, Your Honor.
All right, Mr. Gupta.
Thank you, and may it please the court, Deepak Gupta for the plaintiffs. It's good to be back with you in person. I think it's important at the outset to try to clarify what is at issue and what is not at issue. The only question before the court on remand is whether the panel's prior published decision is consistent with the Supreme Court's decision in TransUnion versus Ramirez, and the answer is that it is. The merits are no longer at issue.
It's a little deeper than that, because TransUnion goes to the subject matter jurisdiction of the court, the power of the court to act. And if there's no standing of the plaintiffs, it's Article 3 standing, then we don't have jurisdiction to hear the case.
Well, that's right, Judge Niemeyer, and so
TransUnion honed in on that concept.
Well,
they sent this one back to say, analyze it under TransUnion.
My friend...
I want to make sure when you said that's right, are you saying it's right that based upon, if we follow Judge Niemeyer's statement, we don't have subject matter jurisdiction over this case?
No, he's certainly not right about that. What I'm saying is Judge Niemeyer is...
Right, I'm just saying...
Yeah, I'm not saying that.
If we follow that, then that's essentially what's being saying. We don't have subject matter jurisdiction over this case.
If there's no standing, there's no subject matter jurisdiction. Correct. Judge Niemeyer is right about that.
And I'm not talking about saying there is subject matter jurisdiction nonetheless. That therefore you can't go back to state court.
No, I think I was just trying to agree with Judge Niemeyer that the question here is subject matter jurisdiction, and the question is whether TransUnion changes anything about that. This court had an analysis of Article 3 standing in its opinion, and as you said, Judge Wynn, it was bottomed out on pocketbook injury, and TransUnion didn't change anything about the law of pocketbook injury. In fact, TransUnion clarifies the correctness of this court's decision. Here's the only thing that the Supreme Court said about pocketbook injury. It made clear that in the Supreme Court's words, certain harms readily qualify as concrete, and among those, the most obvious are monetary harms. The rest of the TransUnion opinion is about different forms of what the court called intangible harm that are not at issue here. My friend was able to persuade the Supreme Court to send this case back by characterizing our theory of standing as a risk of harm theory. The first suggestion that this case had anything to do with standing on the basis of risk of harm was in the petition for certiorari. That's never been our theory. We disclaim that theory. The only theory is the one that this court credited in its published opinion, which is that all of the plaintiffs, every single one of them, paid money for an irredeemably tainted appraisal. And that is a simple theory of Article 3 standing. It's more complicated in most product liability or antitrust or securities cases where you have to engage in counterfactual inquiries into what portion of a charge might be attributable to the harm. But here, there was a specific denominated fee for the appraisal. This court has concluded, based on abundant record evidence, that those appraisals were irredeemably tainted. And that's the end of the matter. That is Article 3 injury.
So if we just reissue this opinion and add a line that says, we have considered TransUnion as you directed, and we stand by our opinion.
I think that's precisely what you should do, Judge Floyd, and that's actually what happens in a great number of cases that are sent back on GVR orders. We cited some studies on this. Many times, the Supreme Court simply, they don't spend a lot of time looking at these decisions when they send them back with a GVR order. There's an allegation by one party that something in a new Supreme Court decision warrants a look again at the case. And this court should look again and conclude that its previous analysis was 100% correct. TransUnion does not change anything about the law of financial injury. And if it changed the law in a case as simple as this one, it's hard to imagine how you would have Article 3 standing in the kinds of cases I was describing, where financial injury is far more complex. So I think, what my friend has been able to do is inject in all sorts of additional questions about relitigating the merits, relitigating class certification, but the only thing that you have to ask on remand from the Supreme Court here is, does anything in the TransUnion opinion change anything you said in your prior published opinion?
Does it matter that TransUnion concern a reputational type injury as opposed to an economic injury?
Well, I think that's what made TransUnion a harder case, because it did not involve a classic financial injury. Remember, none of the plaintiffs in TransUnion paid anything to the defendant, and the same thing was true in Spokio.
The court and its comments went out of its way to make clear that while it was dealing with reputational damages, it was also dealing with monetary damages and other forms of relief. And many times they said that explicitly.
That's right, Judge Niemeyer. I think it's very important to distinguish the form of relief that the plaintiffs are seeking from the form of injury that they're claiming, and that's what I'm talking about. Nothing in TransUnion, nothing in Spokio, nothing in these more difficult cases involves plaintiffs who are paying money to a defendant for a product or service, which is what you have here. And that's why you have these more difficult questions where there are abstract forms of harm.
A little more out of the way question, which was already debated. TransUnion also adds a whole section that talks about that every member of the class has to satisfy the standing.
That's right.
It has to be demonstrated by the plaintiffs. That has almost conceitedly not been done in this case. So
no, I don't think that's right at all, Judge Niemeyer. I think that this court's prior opinion already concluded that every single member of the class paid the fee for appraisals and concluded that there was Article 3 standing in precisely the same way for each one of the class members. Last time this case was before this court, we all assumed that it was the rule that each class member had to show standing.
They paid for appraisals, but there's no evidence that, number one, that every class member's estimate of value was before the appraiser. Number two, there's no estimate of value that the appraisals were in any way tainted as to each class member.
Well,
in other words,
actually,
all you have is the amount of fee paid, which was required by the bank. The bank hired the appraiser, and the borrower has to pay that fee as part of the transaction.
the amount of the fee paid by each class member in just the same way is the basis for Article 3 standing.
Criteria that makes it a damage.
Right, and I think we have to be really careful not to conflate standing and the merits. This court has been clear, including at the summary judgment stage, that standing and the merits are separate, and when you make the Article 3 standing inquiry, you assume that the plaintiffs would prevail on the merits. Now, I understand, Judge Niemeyer, you may disagree with me and conclude that my clients should not prevail on the merits, but I hope I can persuade you that we at least have standing to come into court and then lose on the merits.
Standing, you have to show that each person had a concrete injury by reason of the alleged wrong.
Correct.
And if we have no evidence that these people suffered any of the wrong, in other words, that, number one, their own estimates were provided to the appraisers, or the appraisers looked at them, or relied on them, then they weren't injured.
Well, with respect, Judge Niemeyer, that's just relitigating the merits, and I think what this court concluded based on
include the injury.
What this court concluded is that, and I think correctly, is that all of these appraisals were irredeemably tainted because the buyer's estimated value was sent to the appraisers, and in fact,
it's been established not to be so.
That is not.
You have not demonstrated that in this case, and that's your burden.
That is, it's just not the case that we haven't demonstrated that. What this court said in its prior decision was that it was Quicken's standard practice to provide the appraisers with those estimates, and a spreadsheet in the record, and this is Joint Appendix 730, shows that Quicken included the owner's estimated value on every appraisal order regarding loans refinanced in West Virginia during the relevant period. So that's the entire class. Standing is the same for every single class member. This court got it exactly right in its prior published opinion, and all the court needs to do is reiterate the same analysis and explained that TransUnion changes nothing about that. I do want to quickly, while I'm up here, mention the two cases that I'm sure we'll hear about if you give Mr. J time for rebuttal. I know he went over, but I do want to address them. There are two cases by Judge Smith from the Third Circuit. They're the only two cases really on Article III standing that my friends are relying on. And I think they're really marginal cases, and the fact that this is the best they can do shows how different this case is from the cases that go south on Article III standing. The first is a case in which plaintiffs sued to try to enforce tire registration requirements. It's the Thorne versus Pep Boys case from the Third Circuit. And there you had a plaintiff that was just trying to enforce a regulation, a federal regulation that had no private cause of action that required tire dealers to register cars. But the tire dealer there didn't charge some kind of tire registration fee. They just sold the plaintiff a tire. The plaintiff bought the tire, there was nothing wrong with the tire, and the plaintiff tried to sue over that tire registration failure. And what the court said there is you haven't proven any financial harm. This isn't a worthless product. It's not even a product that's worth a little bit or a tiny bit less as a result of that. And so those are the kinds of very marginal cases that produce potentially difficult inquiries about financial injury.
I thought this case was about borrowing money. Each borrower sought to borrow money at a certain rate and a certain amount and use the money to improve their financial situation.
That's absolutely right.
Just a minute, please.
Sure.
Each person made an application to borrow money, and as a condition of that, they agreed to pay a fee that the lender would incur in hiring an appraiser.
Right.
And that was a necessary cost of fee. They did not hire the appraiser. They didn't see the appraiser. They didn't talk to the appraiser. They were interested in a loan. And so why isn't that analogous to registration in the Third Circuit?
Yeah, and again, I understand you disagree with me on the merits, but all of that is at odds with what the panel said.
Let's analyze.
What the panel said about the merits, and I think this is right, is that the plaintiffs were all unconscionably induced into a loan transaction through the tainted appraisals. And appraisals are central. The amount of the loan is central to the loan transaction. And this was
the bank, not to the borrower. The borrower couldn't care less. If the loan is made without an appraisal, they couldn't care less. They were not affected by one way or other on the appraisal.
West Virginia's
Everything they wanted was the loan to go through.
West Virginia's legislature made a different judgment when it legislated to ensure that lenders would not coerce appraisals into tainted appraisals, understanding that it affects the integrity of the process and has a consumer protection impact. And again, that's the merits. We can disagree about the merits, but I think it would be a really big transformation of the law of Article III standing to preclude plaintiffs from being able to even go into court and get their day in court when clearly they paid money out of pocket for what they allege and what we've proven, I think, is an irredeemably tainted product. Thank you.
Well, let me ask you this. You brought this action under the West Virginia Consumer Credit Protection Act. Could it be as simple as that your suit is predicated on an unlawful practice?
Yes.
That is tainting an appraisal?
Yes. Yes, Judge Floyd.
As simple as that?
Yes, we paid money, if you want to put it this way. We paid money, we paid an unlawful fee. We paid a fee for an unlawful service, for a service that this court has already concluded was tainted. This is not a difficult case for Article III standing. This is a simple case for Article III standing. I realize that the Supreme Court has raised some very difficult questions about Article III standing in intangible injury cases, but this isn't that. This is as simple as that. It's a simple consumer protection case. Now, there are some difficult questions about what the...
It seems to me if you recharacterize this case in accordance with the historical facts, the plaintiffs got their money. They were not prompted to go in underwater. They paid the They paid the transactional costs, they were loaned, and they got their loans taken care of. And they answered a survey, they found the whole process to be excellent, 5 out of 5. A few years later, the practice by industry rule was changed, whereas you do not provide the borrower's estimate to the appraisers. But at the time these loans were made, the common practice was that you do. So the whole process was carried out normally. 2 years later, the change was made, and this lawsuit is essentially a lawsuit just challenging a new rule retroactively, which is the type of abstract claim that the Supreme Court is troubled by.
So, Judge Niemeyer, I don't want to try to persuade you that your dissent was wrong.
Well, I don't need to persuade, just focus on the facts.
I'm trying to. What this court said is that these were particularly questionable practices. That was this court's words. And that even at the time that Quicken was engaging in these practices, regulators had raised concerns. And it became a universally condemned practice by the end of the class period. And the focus...
As you recall, those statements were made in the context of an industry that was being raising, the whole center was on appraisals. And if you keep upping the appraisals, you allow the borrowers to make bigger loans than they can handle.
Right.
And then they go underwater.
That's right.
The whole idea was to protect the borrowers who went underwater with this undue practice. But these two borrowers bought within their means. They bought within the original appraised amount and in one case, the revised appraised amount. And it didn't fit any of those patterns, and the loans were made in accordance with the existing practices.
Judge Niemeyer, I think that with respect, the possibility of people going underwater and all of the potential harms that could consequentially follow is a distraction when you're asking about Article III standing in this case.
The whole basis for the change.
And one way to think about it is, imagine that the West Virginia legislature had passed an even simpler statute. They had simply said it is illegal to charge money for an appraisal where the lender provides the borrower's estimated value to the appraiser. Imagine that's the case. And it's a different case than this one. It's a simpler case. But the theory of Article III standing would be precisely the same. We would have paid money, the charge would be illegal, and then we would be entitled to get the damages as a result. Now, the reason that the West Virginia legislature would have passed that hypothetical statute is presumably because it had concerns about people going underwater, about the integrity of the entire process, and all the other things you're talking about. But that wouldn't be the basis for Article III standing, and it would be quite strange to say that because the legislature had those serious concerns in mind in passing that statute, that somehow deprives the plaintiffs of standing where they would otherwise have it.
Take Judge Niemeyer's argument about retroactivity. I mean, the statute doesn't provide for a retroactive application of this unlawful practice. So, unless you have a reason to say so, but why shouldn't the class be limited to those who paid this fee after the legislature passed the statute addressing this practice?
So I was just imagining a hypothetical statute, and in my hypothetical, the statute, just as in this case, predated the class period, so there's no retroactivity problem. I agree that if there were a statute passed after the conduct was engaged in, then you would have a retroactivity problem. That's not the case here because we sued under the law as it existed throughout the class period. Now, I do think it's important to point out that, as you said earlier, standing is not dispensed in gross, and so standing has to be analyzed for each claim and for each form of relief sought. We've mostly been talking about the unconscionability claim, which makes sense because that's the claim that this court affirmed, and it's the lion's share of the liability here. I think the standing inquiry is basically the same for both claims because in both claims there's a financial injury. The plaintiffs paid these fees for the appraisal, and that's the focus of the action. But I thought it would be useful to just point out very briefly that If you're clarifying the opinion, if you're adding some language about how the opinion is consistent with TransUnion, you could also explain that the theory of standing is the same for both of the claims that the plaintiffs are pursuing, and that this is, there's Article 3 standing for each class member because each class member paid the requisite fee. Thank you.
If we lack standing here, do you still have an action in state court?
I think the law in the Fourth Circuit is that when the federal court loses jurisdiction because of lack of Article 3 standing and the case came from state court, the case has to be remanded to state court. Now, Mr. J tried to resist that conclusion by pointing to the ALIG's individual damages claims, but those claims are not live in this case. They're not before this court, and I think they have nothing to do with the analysis. And so,
What do we have before us? We have what, the statutory claim and a breach of contract claim?
correct. And you've remanded on the breach of contract claim. If there are no further questions, I'll sit down.
Well,
Sorry.
In the prior opinion, we did indicate or reject the argument that plaintiffs were not injured because they benefited from obtaining the loans. Did TransUnion affect that determination by this court?
No, TransUnion has nothing to say about the merits of this case. TransUnion only has anything to say about the paragraph or two in which this court concluded in a very straightforward way that there was paradigmatic financial injury here. So I think the only task before you is to look at those paragraphs and to see if there's any language that needs to be added to make clear that the court's opinion is consistent with TransUnion. And I think, frankly, if the suggestion had not been made by my friends on the other side that this case had anything to do with a risk of harm theory, I doubt we would be here in the first place.
All right, thank you.
Thank you.
Mr. J.
Thank you, Your Honor. I really just like to focus on 3 points in rebuttal. One, dealing with the colloquy that Judge Floyd had with my friend. The second, dealing with which appraisers actually saw the borrower's estimate. And the third, on the jurisdictional question. So, Judge Floyd, you asked my friend basically whether the injury from paying the fee was paying for an illegal appraisal or something to that effect. And he hypothesized a statute that the legislature could pass that would make the appraisal illegal. Now, they had a claim against the appraisers under a different statute saying that they'd violated their professional standards. And that claim failed. And the reason for that is that nothing in the West Virginia law made these appraisals, per se, unlawful. So if you're going to say that the injury is paying for the appraisal, you have to get something less than what you paid for. And that's precisely what they don't have any evidence of, because, and this is not disputing the merits, because remember that this court interpreted the merits of the West Virginia claim not to require any proof of reliance, not to require any proof of damages. So it includes within the class even people whose appraisers never actually saw the borrower's estimate of value. So there's nothing in the record suggests that these plaintiffs expected to get an appraisal that didn't just comply with the applicable professional standards, but complied with the level of independence that our friends on the other side say is required. Not by the appraisal law, but by this consumer protection statute. So in other words, they got what they paid for. That's why the $350 on average is not injury, that they have not shown anything in the law that makes those appraisals unlawful per se.
In the prior case, we did conclude that they got less than they paid for. We said they got a tainted appraisal.
You did say that.
How did TransUnion change that?
Right, because what did the court say? It said tainted by exposure to the borrower's estimate of value. And TransUnion talks repeatedly about exposure and says that exposure to a risk of harm is not cognizable injury. The only way in which the court could say class-wide that everyone's appraisal was tainted was by saying that the mere risk that showing the appraisal company on the order form the borrower's estimate of value, that's enough to make the appraisals worthless.
Well, I thought the point of my question, and maybe I didn't ask it right, I thought their theory was we're suing you over this practice and nothing else.
And the practice was lawful at the time. The practice was consistent with professional standards, and as the court pointed out, it was quite common.
Well, was it at the time, do you mean those borrowers before the passage of the act, or to all?
It's not the statute that they're suing under. There was another law, change in law that Judge Niemeyer refers to, and that's after the class period, that says don't provide the borrower's estimate to the appraiser in a refinance loan. So so they're relying, I'm sorry.
Could they maintain a class post-statute where you engage in this practice?
I think that someone would have standing if there's a law that says don't charge this appraisal fee, and the appraisal fee is charged in violation of the law, then that could be the basis for a claim of standing. But that's exactly what you don't have here. All the court says in its opinion, toward the end of the opinion, the court says that it is reasonable to suppose that the borrowers each assumed that the appraisal provided a valuation of their homes without being tainted by the borrower's estimate of value. But that's just a risk of harm point. So that's one of the points I wanted to make. The other point on the merits is to Judge Niemeyer's question to my friend about whether the appraisers actually saw the borrower's estimate. And he said every single appraiser did, and that's just not correct. We would point you to Joint Appendix 1052 and 1059 to 60. And we've pointed this out repeatedly in our briefs, and I have not seen a response to them from them about why they could have standing for injury if their appraiser never actually saw the number on the order form. And this is just, the person who takes the order and schedules the appraisal is, an administrative clerk. It's not the appraiser who goes out and looks at the house, and that's what the record will show you.
The question not more so that they didn't get something independent. I mean, you recall the plaintiff's example in the brief, the one about the surgeon, and the surgeon, charges $1,000 to get your second opinion. Then he goes to second opinion, gives opinion, and the question is whether the person has gotten something, an independent evaluation. And why is that not here? You pay $350. Someone goes and provides an estimate to the appraisal. Why is that? I understand the risk of harm, but I'm not following it with regard to why is it not? You didn't get something you paid for. You paid for an independent appraisal.
So two responses to that. One, our friends on the other side smuggle into their hypothetical that the doctor promised that the second opinion would be uninfluenced by the first one. And second, and relatedly,
Isn't that inherent in an appraisal, though, that is
no.
independent? Or do you think appraisals, when you get an appraisal from someone, it doesn't have to be independent. It can be someone else's appraisal that's helping you out with it. I thought that's what you paid for. It seems like there's even a regulation in terms of appraisals that you have to do it independently.
But these appraisals all comply with the independence rules. That's the point, is that this court's
They all certified that they were independent
Right.
When they signed them, in the form that they signed them. And that had an independence. So there would be a requirement to show, in fact, a disclosure of the borrower's estimates.
Right, and exactly.
Does the certification make it so if, in fact, you can show that that something was provided in advance? I mean, it's like a certified complaint. I mean, if you got a certified complaint, they all said it in the complaint that is certified, this is what it is. Why is that not sufficient if you can just say the certification of an appraisal alone? I mean, even with the surgeon, you say promise, but if the second surgeon acknowledges, yeah, I got this, I mean, why is that not a challenge to the independence of it?
All of these appraisals are in compliance with the professional standards, and that's exactly what someone getting a refinance loan would expect.
We're dealing with issues of fact here, and all these appraisals are in compliance with professional standards. That's boilerplate language. I mean, I know what that is. That reads very well, but if you got evidence to show otherwise, why is it not challenging that independence?
Remember, Your Honor, it's not showing that they were in violation of professional standards. These were all in compliance with professional standards. So we're not just talking about an appraiser reciting something that might not be true. It's true.
To follow up more pointedly, is there evidence that the appraisers in the class, in this case, did not get the borrower's estimates?
Is there evidence? So there are 2 declarations from appraisers who performed appraisals for Quicken Loans during the time period, and they said that one of them says, when I went out to do an appraisal, I would not have seen the estimate on the order form until after I'd done the appraisal and arrived at the value. And the other, it's a little bit less detailed, but it's to the same effect, said that the order form goes to the office admin clerk.
So if I understand correctly, your argument is that with respect to some appraisals at least, there is no factual support for a taint.
There is no factual support for a taint. That's why this class definition is so overbroad, because the estimate doesn't even have to have been shown to the appraiser for the borrower to be within this class. And that really is kind of the fundamental point, that the district court
That is one point. I don't know if that's the Supreme Court's interest, but that's a point of class members satisfying the standard. In other words, the Supreme Court did go out of its way. I mean, they said, for instance, every class member must have Article III standing in order to recover individual damages.
That's right.
And then it goes and it says that the plaintiffs must demonstrate that for each one. And so that is clear as a bell, and that is a problem. I don't know if the court sent it back for that or sent it back for the standing that the ALICs basically were not harmed in any sense. In other words, they suffered no injury by reimbursing the bank for its appraisal fee.
Right. And people whose appraisals were accurate, as the court acknowledged in footnote 22 of its opinion, those people aren't harmed either. Right. The last point, just to answer Judge Wynn's jurisdictional question. If you look at the judgment, page 627, starts at page 627 of the appendix, you'll see all of the claims in this case, and any one of those claims that's not at issue at this point could sustain federal jurisdiction in this case. Remember, like, the removal is jurisdiction over the whole controversy. So if a claim, let's say claim 1 were dismissed for lack of standing, then okay, then they could maybe refile that somewhere else. But the whole controversy wouldn't be remanded.
I know you're so interested in the class, and it's very important because that's where all the money is in this case. But you don't call the claim of a class member anything more than a claim that is represented by the class members. And so you need to, the class representatives. So you need to focus on the class representatives' claims. If they don't have standing, then there is no class. They have to represent the class, and or their lack of standing also represents the class's lack of standing. So now there is always a doctrine that if you knock out 2 plaintiffs, you can look for some others, but that wasn't done in this case.
Everything you said is true, but as you just read from TransUnion, even if the named plaintiffs have standing, that's still a problem if a large number of members of the class don't have standing.
Well, that seems to be your main point, but I'm not sure that's the Supreme Court's main point. But anyway, I see we've gone through the red light.
I do want to follow up at least a little bit on that, because that's an interesting point. It seems to me if we go in that direction, then there's just no class. You're just saying even if you show injury in fact, or you show you have something as the named plaintiffs, and, from Judge Niemeyer's perspective, there's no such thing as a class action.
I don't agree with that, Your Honor. I mean, the question is just under 23B3.
In this instance, there's not one. There's not one you can, how would you show, what would be necessary in order for it to show standing in this case?
I think they'd have to pursue these as individuals because we haven't seen any basis for them to do it as like common evidence.
But I'm saying, so you're saying a class action with anyone, if there's a group of people who meet everything the plaintiff does, they cannot be certified as a class.
So TransUnion makes clear that you have to have standing beyond just reciting the elements of the cause of action, right? Like winning on the cause of action is not enough, and that whether you have standing is something that you can't dispose of just based on the named plaintiffs.
So there's no such thing as a class action.
I don't agree with that. The question is, can you prove standing by common evidence? In some cases, I think you would be able to.
There's no such thing as standing in this case.
In this case, I don't.
You can't have standing with these kind of facts. You can't have standing even if you show you had to pay, they paid this fee, and the fee was actually looked at by the appraisals, which I'm using, just going following where we're going here with this. They actually looked at it. There's that difference. He was influenced by it. Doesn't matter. You got to do every one of these claims individual. You cannot have standing. Is that your answer?
So I do think that you'd have to show something like that to show injury in a case like this.
So that would give you standing?
So I want to make sure I heard.
I'm just trying to follow Judge Niemeyer's hypothetical that even the named plaintiff don't have it. If they don't have it, then you can't prove standing in a case like this.
So maybe I misheard your question, but I thought you asked me to assume that they could show that they were injured from the loan. But
Well,
did
show
I
that they
mishear
could
that?
show the same thing as the plaintiff. Every last one of them showed the same thing. You're saying you couldn't certify that as a class.
I am saying that because it couldn't be done by common evidence. No, if you wanted to give the plaintiffs another chance to do that, that would be up to the court.
The critical element is the disclosure of the borrower's estimate to the appraiser. And you're saying that disclosure didn't occur or the appraiser didn't see that in every case.
That's definitely right, and they can't show harm.
Even if they did, you don't have standing.
Even if the appraiser saw it, I think that wouldn't be enough to have standing. That's
So what
right.
does that got to do with it? I don't follow that critical point at all. If you see it, what's the difference it's going to make?
So I think that the fact that
under this kind of discussion, I don't get it.
the fact that some appraisers never even saw the borrower's estimate, I think highlights the fact that there are people in this class who really can't prove injury. Those aren't the only people who can't prove injury, but I think it really puts a fine point on it. But
If every appraisal got it and said, yeah, we saw it, still wouldn't make a difference.
that would not be enough to have standing. That's right, because there's
Well, that point, I don't know where that point goes.
so it's part of our argument. It's certainly not the only part. Ultimately, the district court didn't even look at the unnamed
I
standing.
think we've heard it, and we've let you go on a little bit.
I appreciate it very much, Your Honor. Thank you.
Appreciate your arguments. It's our practices. Well, we know you well, and you probably know our practice well. You've been down here, and we're happy to have you back again. Our practice is normally to come down and shake hands with counsel. It's something we are not going to give up. It's a tradition, goes back to Chief Judge Parker, and we're very proud of it. But we have continued our protocols on the COVID, at least through this term, and we don't know when we'll pull it up. So as part of that practice, we're going to refrain from actually physically shaking your hands, but we're shaking your hands conceptually. Thank you for coming, and have a good day. We'll proceed on to the next case. All right, next case we'll hear is Bass versus Weinstein Management. And Mr. McGinnis, whenever you're ready, we'll hear from you.
Good morning. May it please the court. Edward McGinnis for the appellants in this action. There are two methods under North Carolina law in which a statute can be held to have retroactive effect, and two separate tests for those two different manners. And I think it's important not to conflate the two. The first argument that my friend has made is regarding what we've styled as the clarification argument. A clarification to a statute means the law was always this way. And so it has retroactive effect because it always meant this way. The test for that under the North Carolina Supreme Court is a case called Ray. And what Ray says to do when evaluating whether or not an amendment is clarifying is pretty simple. It just says look at the two statutes and compare them. If there are substantive changes to the statute, it's a substantive amendment with prospective effect. If there are no substantive changes to the statute, it's a clarifying amendment and it can have retrospective effect. The court has already looked at this in the Suarez case, an unpublished decision from last year regarding the 2018 amendment to North Carolina General Statute 4246, and found, applying Ray, that there were three changes from the 2009 statute which was in play at the time Ms. Bass was charged these fees. Number one, added the right to charge filing fees simply for filing an eviction. Number two, charge sheriff service fees. Number three, expand the right to charge attorney's fees. The analysis here on the clarification argument is identical. 2021 statute has the exact same substantive issues as 2018. And so if we want a clarifying amendment, we have to compare 2021 with 2009 and look and see whether or not there's changes. And there's 3 changes, exactly like there was in the Suarez opinion. My friends over there have remarked, there were 20 pages in their brief about clarification, and they talk about legislative intent, and they don't talk about the Ray test at all. And the reason for that is because they know how Suarez came out. There is no magic.
The issue here that you bring is the clarification under the 21 amendment of the 2018 law.
So what has been argued is that the 2021 amendment is both clarifying and retroactive, the first one being clarification.
That part I got, but I want to know what the 2018 statute, you're not arguing with regard to that.
No.
In terms of what it did. You're saying you can have a matter in which an individual has a right to do something, let's say statutory, we'll use that word. The legislature then passes something and say, oh, no, that's not so. Court determines it, well, yes, it is. Then it passes another act, says, well, it is. We're gonna go back and say, yes, it is retroactive. You're saying that second time around, let me just get to the nub of this. This is what's troubling about this. And I know the difference that's articulated between statutory and common law type rights and the vesting of them, things. But individuals pursue an action, and for whatever reason, we know the General Assembly didn't just sit there and read that statute and decide, I want to change it. I mean, it could be the plaintiffs went to them and anybody went, and which they can do. There's nothing wrong with it. The plaintiff can go in there and lobby to that General Assembly, change a rule for ordinary folks who are applying for it, and they do it, and the court says, no, what you've done is that's a substantive change you've just made. And then they come back and say, oh, no, it's not substantive. I guess it could be retroactive.
Right. The problem on the clarification argument.
So how does the General Assembly change something that the court said was substantive into non-substantive with an amendment?
They can't. That's the issue here. If they're clarifying the amendment, it can't have been a substantive
I got the
change.
clarification. Don't be argumentative. I'm just understanding what is substantive. If the court determines, seems like that's a question of law, it's substantive. But then to clarify is like saying, no, it's not substantive. But how do you determine that? I mean, the court told you it's substantive. So now you come back and said, no, it's not substantive?
Right. Legislatures make laws, courts interpret them, and what's been argued here is essentially that legislatures ought to have the right to have an extrajudicial review of the court decision. That's particularly problematic in the context.
Typically prospective, though. I mean, it makes sense that, from now on you can do these things, but to go back for someone who's actually sitting in court, paid all this money, getting ready to go to proceed on, you're going down to twos because you're going to lose it because the statute had provided the remedy. They come along and said, no, you can't do it. We're going to help these people out so you don't have to do that.
Particularly problematic.
They can just do that.
No, they can change the law.
Let me ask you that. That's the question I thought this whole case was about. I agree with what Judge Wynn is asking you about, but I would take it a step further. Let's assume it's a substantive statute, which is usually, in the ordinary course, only prospective. Almost everybody agrees on that. Unless, and I think the general proposition, it's prospective, unless the legislature indicates otherwise. And the 2018 statute didn't indicate otherwise. It was unclear, so the presumption that it was not prospective applies. But then the legislature comes and says, it is our intent to make this substantive thing retroactive. And they said that. That's clear as a bell. So the question now is, can that be applied to you where the case is still pending? I always thought the answer is that they could do that unless they've taken away a property right of some kind under the Constitution, some kind of, and that's the whole analysis here, is if it's a pending action and not finalized by judgment, it's a little bit like getting a permit to build a house, and before you go there and start digging, they withdraw the permit. You know, we've had those types of cases, and we've always said until you start actually digging, you haven't got a vested right. The same thing with respect to the Supreme Court's addressed whether professors have property interests in their employment before they're become tenured or after. And I thought that's the question here, is the exception where Congress, that's a legislature made it clear, why can't they do that? And your argument has to be because they took away my property right. And then the whole question is a pending action for a claim for mischarging, is that a property right, or can that be taken away before you get a judgment?
I think that's the second test. So
Well,
that's,
it's not a second test. It's necessary. The first test doesn't get you anywhere. The fact that it's substantive doesn't get you anywhere. What it gets you is a presumption that it's going to operate prospectively.
I agree.
In this record, we don't have that. We have the presumptions overcome by the legislature. They said clearly we want it retroactive. So now your claim is basically, can the legislature act retroactively here in the context of your circumstances?
Right.
And that's the debate, I thought.
It is. They made the clarification argument, and so we wanted to address it quickly. The retroactivity argument.
Well, I thought North Carolina law was real clear that with regard to statutory rights, they don't vest until you have a final judgment, unlike the common law. I mean, take the example of libel, for example. They couldn't change the ability to get compensatory damages under the common law for libel. But if they had added a provision for punitive damages, and they take it away, they can take that away. Isn't that the law in North Carolina?
I don't think so, Judge Floyd. I think what my friends have argued essentially is that with statutory claims, there is only one way for a right to vest, and that's through a judgment. And they cite two cases that don't involve injuries. Our position, and we styled this in our brief, is it's sufficient but not necessary. If you have a judgment, that's sufficient, but there are other ways in which statutory claims can vest. There's a litany of cases associated with that, because if there is an injury, what the Open Courts Clause says is every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law. The Forrest case says that these claims that we have before the court are injuries. Now, when you don't have an injury, when you have a penalty case or when you have claims under statute that don't involve injuries, perhaps you do need the judgment. Some of the cases involve that, but there are plenty of cases in which there are other paths to vesting rights, not just injury. For example, the Williams case that's been cited on both sides. That case involved a maximum price for train tickets based on a per mileage rate, purely a creation of statute. They found that that right had vested without a judgment. The Lester Brothers case involved at corporate liability at the time. If you only had two owners of a corporation, you couldn't get corporate protection. The court found, after they changed the law to say it can be one, they said you can be, at the time, the law of the state made them individually liable, and they had a vested right in that liability. So in that case, pure creation of statute, vested right in liability, no judgment. The Heath case that we've cited, another pure creation of statute. If you got bit by a dog, the county would reimburse you for your injuries and seek indemnity from the dog owner. Pure creation of statute, the court found that the county had a vested right against the dog owner and that the plaintiff had a vested right against the county. That judgment was affirmed. So that case was on appeal, no judgment, vested right. The Heath case we just talked about. The Falkenberry case that we mentioned, that involves the contract clause. State employees had vested rights.
Is there a relationship between public policy and common law?
The relationship between the public policy?
Public policy and common law. Is it something akin, or is it pretty much the same? Or
The legislature establishes the common law and they can modify the common law.
what about public policy? Is that similar to common law? What is that?
I think it can be. I think that the public policy of this state at the time was that these fees could not be charged. And so when those fees were charged,
Would that be the same way as saying the common law at this time?
I think if you have been injured, and we've gone down the path of injury, so you can have other paths to a vested right, whether that be a statute of limitations, the passage of time, a lien, a judgment is one way, but an injury is another way because the Open Courts Clause protects it.
If the common law establishes something and is codified in a statute, so to speak, and then subsequently you take it away, does the right of common law apply in the retroactive sense? Because essentially what you've done is you've, by the second action, taken away the public policy which the initial statute characterizes. It said this is contrary, you saw exactly where I was going with this, contrary to public policy was the reason they did the statute in 2009. It says contrary to public policy, come back in 18 and they get rid of it, so to speak, and then 21, you say clarified. The question being, if it was a codification of the common law by the initial statute, and then you come back and get rid of it, have you not essentially just gone against the common law? Which means that the common law would be what was covered up until, because it was a codification of it, until 2018. Does that not follow?
I think there's some, there's some issues with potentially modification of the common law, and that's not to say that public policy can't change and legislation can't be changed, but when you have an injury associated with the public policy at the time.
That's all a little bit general. If we get to this case, we have a rental agreement which covered by contract law, and the rental agreement allows for the collection of these fees for ejecting and attorney's fees and so forth. The common law of contract was modified by the statute in 2009 saying the contract cannot provide for the collection of ejectment fees. And then the legislature removed that. So we're back to the common law enforcement of a contract in this case. Isn't that where we're at?
I don't think so.
Your client agreed to these fees when they signed the contract. There was no common law that said they couldn't charge ejectment fees.
Well, there was a statute that said you cannot even put them in a lease. The clause in the lease was unlawful when it was put in there. You can't simply say, well, even though we were breaking the law, you agreed to it. So under the common law, it wouldn't be an enforceable provision anyway.
Common law would be the contract. There is nothing in the common law that says you can't charge ejectment fees under a rental. The statutory law made it a matter of public policy and said, we're not going to allow the collection of ejectment fees. That was the 2009 statute.
I think the distinction between the common law and the statutory claims is a little bit, it's not as black and white as you might suggest because you can have a statutory claim with an injury. I want to quote from...
Of course you can, but you want to constantly work with general concepts, and I just want to focus on this case. This case is a contract case or ejectment for failure to pay rent. And so the ejectment fees are provided for in the document. The 2009 statute prohibits that as a matter of public policy. That was done by the North Carolina legislature. They took that out in 2018, and they made it retroactive in 2021. Now, it seems to me everything that you're claiming is based on what the legislature did, because if you don't rely on what the legislature did, you're back under your contract obligations. And so the question that remains is what I believe is my first question, is was it improper for the legislature to make a statute retroactive even though it's substantive?
It was.
That to me, you're sort of dancing around that.
I'm not attempting to, Judge. What we are arguing...
Okay, then that's fine. I didn't interpret your dance correctly.
What we are arguing is the contract should have never had it in the first place, but at the time, there was a pocketbook injury. There was money damages. But
here's the point. The point being the initial statute read that way. It wasn't a contract initially. It said it is contrary to public policy to put those in a lease. Basically, this statute says common law or public policy voids any contracts like that. And what is so when you have 2018, the way I'm seeing is you then establish a contract right in 2018. This is a codification of the common law. I'm assuming it's a common law. I'm saying the public policy is what I'm using here. That may be somewhere else. But it's an interesting question to me that if the common law is such that it makes this the public policy that voids these contracts, you don't have contract law controlling because it says you can't do it until 2018. That's a substantive change.
I agree.
Then to say you're clarifying what has been a substantive claim, well, you clarified it. It was a substantive claim. I'm not following that.
Unlawful to put it in a lease at the time. And so under contract law, it's not an enforceable term. They were wrong to charge it. Charges were paid. There are actual damages. That's an injury under every definition. Every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law. That's the North Carolina Constitution. And so in instances where there is no injury, it may be that you require a judgment. But in instances where there is an injury, there's another path, and it's the path protected by the Constitution.
Thank you. You had some rebuttal, and we've gone over time here with a little bit. Enrique?
Enriquez, Your Honor. Thank you. Mr. Enriquez for Weinstein Management. Let me go directly to your question, Judge Wynn. You talked about the substantive change in public policy versus common law. I would submit that it is the legislature that actually makes public policy decisions. They make the public policy decision. And this area, the landlord-tenant relationship, is one that's governed as a creature of legislation. The whole Chapter 42 deals with the relationship between landlords and tenants. And I think that's different. Judge Floyd is correct that when the legislature creates a statute, they have the right to retroactively take away that statute, provided they do so expressly. And that's what the whole line of cases, starting with Dyer and continuing on in our brief, addresses. I do think this is different than the Suarez.
In essence, what you're really saying, I guess, is that the common law, as of that time, did not prohibit those fees. That you could do it by a contract. Common law wouldn't prohibit it in 2009.
That's correct, Your Honor. And that's what
the public policy is determined by the legislature.
And in fact, you don't have to take my word for it. The Friday decision, which is cited as a 2003 decision, it's important because the lease there said that the tenant had to pay an administrative fee, that's a term from the Friday decision, of $75 plus court costs.
So no question that in 2018, at least from the court's determination, that was a substantive change. 2018, we're stuck with 2018. We're stuck with being a substantive change. Is that correct?
The court found that in the Suarez case that 2018 was substantive.
That's a done deal on that. So the only issue is, once the court says, okay, you made a substantive change here, 2021 comes along, legislature comes back, says it's not a substantive change.
And let me explain why that is. When you look at the statute, two reasons. First of all, as the court in Suarez noted in footnote 5, legislative...
Let me be clear. In other words, to make something not substantive, all the legislature have to do is say it's not substantive.
No, Your Honor. No, they have to actually make a clarifying change. And what they did wrong, if you will, in 2018 is, instead of redefining or clarifying what they meant by fees in H3, they added a new section I, that the court said, this is a brand new provision saying you can collect out-of-pocket expenses. So the court, the legislature, and it didn't say it was clarifying and it didn't say it was retroactive. So the court had to look at that. They said, this looks like a new exception. We're only going to provide it prospectively. That's the decision in Suarez. And you can accept that as a correct decision and still reach a different result in 2021, because what they did then is they went back and inserted the word administrative before fees. And as we've argued, that clarifies those were the fees that they were talking about way back in 2009. They were really only talking about administrative fees. They never intended to restrict all fees. In fact, we know that that's true because court costs were charged on Friday and they were never addressed. In fact, an argument that's not in our brief, but I think is important, is if you look at the subsection immediately before H3, H2, it talks about a landlord who earns an administrative fee or earns a fee, and that earns language was there before. You can't earn court costs. They were talking about these fees that landlords earn by processing the eviction filing and then the subsequent fees for court appearance and appeal. Those were landlord fees, and they don't compensate for the $96 court costs. They're tied to a percentage of the amount of the rent, the monthly rent. It's 5% or then 10 and 12%. Those are earned fees. It's true that a filing fee sounds like a fee, and that's what Suarez said. These are fees. It's a fee charged by the court, but it's an expense of the landlord. It's an out-of-pocket expense.
This has been a good educational case for me. I mean, thought I knew a lot of stuff, but essentially it boils down to if it is purely a statutory right that's conferred, even when you pursue it. Let's take attorney's fees, for instance. You only get those if it's under statute, right?
That is correct, Your Honor.
And so you earn all these attorney fees, and legislation, the other side can go and lobby the legislature, they get it through and get it signed, you won't get a dime.
That's true, Your Honor, because that right to recover attorney fees is a creature of statute, and that the legislature can change it.
And it applies to anything else, not just attorney's fees, but any rights whatsoever that consumers may or individuals may get. All you need is a lobbyist or someone with some sufficient oomph or whatever to go to the legislature and get them to change it. And even if you filed a suit, even if the jury is out there waiting to bring back the verdict, before they bring that back in, if you get that governor to sign that, you won't get anything.
Your Honor, it is true that until you have...
But that is true, isn't it?
Yes, until judgment, statutory rights can be removed. I know they talk about the fact there was lobbying. They ignore the fact that this was unanimously passed by all the Democrats and Republicans and signed by the Democratic governor.
The basis for this distinction of common law versus statutory right, where does that arise from?
Well, it arises from the fact that the legislature's in charge of legislative acts. These are... They can give these...
Does it come from case law? Does it come
Yes, Your Honor.
from the Constitution? Where does it come from?
Well, it is case law. It goes fundamentally to the separate roles of the government. So the courts have to protect individuals in their...
Constitution.
Yeah, I think it is fundamentally constitutional. The courts, we as citizens have certain common law rights that can't be abrogated by the legislature. But when the legislature gives us a right, even in the dire case...
The differentiation between the value of having a common law right as opposed to a statutory right that leads one to say, if you have a common law right, you get that thing vests when you've been injured. If you don't have a statutory right, you only get it from a judge. Where does that come from?
It comes from who gave you the right. So we have our common law rights as a basic...
I mean, that's the John. I'm talking about the source.
Well,
who came up with that idea is what I'm trying to understand.
well, I think it's the North Carolina Supreme Court. Obviously, what this court has to do is guess as to how...
What was the case?
Dyer is really the first case that dives into that, Your Honor.
Dyer did this in that case. So this is North Carolina
And they
law.
cite...
This is
yes,
North Carolina law.
this is North Carolina law.
And there's no way we can certify a question in North Carolina. They don't even allow this sort of stuff, do they?
They do not, Your Honor. That's why you have to guess as to what the North
Just
Carolina...
let us come up here and guess what it is, and they're happy with it and move on.
Unfortunately, they
the
do...
only state in our entire...
But you know, we're so lucky we have Judge Wynn, who's a North Carolina judge here.
I know, you serve...
I can get the Maryland judges and everybody agree with me, because they're telling me what North Carolina law is.
And that's what we're stuck with. I do think it's remarkable. My friends on the other side want this court to recognize a new claim. No court has ever found retroactivity violating the open courts provision. They don't cite a single case. They want you to guess that the North Carolina Supreme Court would create this brand new right that has almost no limit. They're saying under the new Forrest case, an injury is anything provided by statute. So whether it's a penalty, like the cases we talked about, or whether it's a right to collect money or a rebate from the utilities case, or the right for equitable distribution from the Mabry case, all of those would go away under their brand new theory that anything given by the legislature can never be taken away. That's really their argument is...
The legislature could today go and reclarify this, and next thing you know, you got a cause of action. If they go in and you see a law come by tomorrow, that goes the other way, we're back in court. This could go on every year.
Well, under statutory rights, the court has to defer to the legislature. They have the ability to do that. Now, often the courts will only make it prospective, or they'll have a savings clause. You mentioned savings clause in the case prior to us. Those are commonly adopted. They rely so much on Ray as the standard. It's not. Ray was a case where there was no retroactivity. They never used the word clarify. And the court said, because we don't know whether it's substantive or clarifying, we have to do this analysis. I submit Ray doesn't apply here because they have told you it's clarifying. Now, I'm not arguing that it's enough to simply slap the word clarifying on. But here there is more. We've had a number of judges say fees only mean administrative fees because the context was they were worried about landlords overcharging tenants. The reason this gets unanimous legislative support is these court costs have always been allowed. There are good public policy reasons why you don't want to have, the landlord will simply pass that cost on to all tenants. So if it's not the defaulting tenant that pays the filing fee, everyone's rent goes up. That's why this is, as a matter of public policy, landlords aren't getting rich on this. It's an out-of-pocket expense that they're getting back. That's been the history. I think it's undisputed.
The problem, and I follow that, but you know, they passed this act, and they've been meeting. They could have, if they wanted to, they could have done something, you know, during that time period. They didn't have to wait until someone actually sued, get in court the whole bit, and then go and rush something through and put it through, and then change the law on it. So I mean, I know that deals with a whole different matter, but the whole business of, you know, I think it just comes down. Your argument is, and seems to be pretty much what's being said here, is that they can do what they wanted to. If they give you a right, they can take it away. That's the end of it.
Yes, Judge.
Doesn't matter when they take it. As long as you haven't been, you can have that so-called right. If it's just statutory, you won't have it. But let's go back to the other question. If that statute codifies a common law, would that follow?
So I think it really, I think if it's created, it's a potentially more complicated question.
Okay, we're good.
That we don't have here.
It's not before us.
It's not before us, right? This is here it's undisputed that the law contracts would have applied beforehand and they contractually agreed to pay the fees. So the only reason, you know, that they did it here is because of this statute. The reason it took a long time is no one thought there was anything wrong with charging the court costs and service fees to tenants. So the law was adopted in 2009, but nothing happened until 2017. No one brought a claim because everyone thought it was fine.
Well, it caught the attention of the legislature to make this change in 2018 in the midst of all of this. And
the
come
lawsuits.
back with that.
Absolutely.
Was it a court case that did it? And how did they?
Well, in the Hargrave case, the court for the first time said, wait a minute, it says any fees and these out-of-pocket expenses cannot be recovered. And then the legislature said immediately, that's not what we intended. We were talking about landlords charging administrative fees for processing eviction, like back in Friday. We never intended to say landlords can't pass on these court costs and service fees, so that's why they hastily passed the 2018 amendment, but they didn't include language on clarification. They never said it was retroactive. So I do think it was a difficult question for the court to answer in Suarez is it substantive or is it clarifying? And I understand the decision that it's substantive. The way it was structured, they added a whole new subsection I. They didn't change the definition of fees. And that's why in 2021, the legislature said, I guess we did a bad job clarifying what we meant. We're going to come back in and we're going to use clarifying in all capital letters. We're going to say retroactive, and we're going to say we're talking about administrative fees. That is what we meant. But clearly we didn't convey that well, and now we're going to make it clear that this
The complainants didn't move fast enough on this case. Maybe it started in 2018. If they'd moved, and maybe it might have been a court, of course. I know they went to a class action, but had they moved quickly before 2021 under your argument, they're good.
Yeah, if they got a judgment beforehand, for sure. That's right. Once you get a judgment, we all agree, my friends and I agree that a judgment is when the judgment vests for statutory rights. You know, and I think the law is clear that for statutory rights, that's only when they vest. So if they had raced quickly and gotten a judgment, you're right, we wouldn't be here. But if it's a pending case, and only if the legislature makes it clear they want it to apply to pending cases, they don't have to do that. But they said explicitly this applies to any case pending on adoption. And they can do that.
The only cloudy part to the case, and I'm not sure it's that cloudy, is once the court says it's substantive, what you've done here, this clarifying of amendment, it seems to me you could come back and enact an entirely different statute that could be non-substantive, but to take a statute that's substantive and then add an amendment to it and say the amendment now makes it non-substantive is a court determination, I guess, still. does that in fact make it non-substantive? And that really probably goes to the heart of it.
It does. That's well said, Judge Wood. I agree that the question is, can they go back, and is it a clarifying change now, given that there's a ruling that, there's a ruling that the prior change was substantive. I think when you read the change, like the reason I talked so long about administrative fees is, that's what they have inserted the word administrative each time that's the new clarification. They've said, wait a minute, maybe we can't just have a new carve-out for out-of-pocket. The court said that was a substantive addition. It was a creation of a new allowable charge. What we really meant was that the only ones we're prohibiting were administrative fees. So it is different. Instead of a new allowed charge, they've gone back and redefined the prohibited charge. So it is different than the last time. Plus, again, with the headline saying, this time we really mean clarifying, and we cited a number of cases saying, when the court says it's clarifying, when the legislature says it's clarifying, that really should end the inquiry. Because the whole purpose of the court is to try to find out legislative intent. The first time, it wasn't clear. And so you had to do the analysis, and the way they drafted it made it look substantive. So I understand that decision. This time, they've tried to make it very clear that it is, in fact, clarifying. The only other point I want to make in connection with their claim of vested rights, they talk a lot about Forrest, which is a standing case. It's not a case around retroactivity. But the standard they propose has no limits whatsoever. If you were to adopt my friend's view and say that any time a statute gave you a right, it could not be taken away, it would overturn not just Dyer, but all the other cases upholding retroactivity that we cite in our case. Bowen v. Mabry would be overturned because the legislature created a right of abatement that then got taken away by the subsequent legislation. Judge Floyd.
The Forrest case didn't even mention Dyer.
It did not.
So Dyer's still good law.
It is good law. They argue that it's overturned, sub silentio, I guess. But you're right. Dyer clearly is good law. But there's no flags. It's true. It hasn't been cited that much recently, but it's because it's an established precedent. It was cited a few times, and it's cited in the Atlantic Railroad case. That's one that my friend mentioned. But what was different there is that person was put out of the train. So the law changed the rates, but the reason he had a cause of action was he suffered the common law claim, which was a recognized tort claim. There's a bunch of old decisions, fun to read if you have time, where people get put out of a train. The train stops at a red light, and you're miles from anywhere. That is an injury to that person. And what the court said is, he still has his claim, not his claim for a refund of any additional monies he paid, but he has a claim because he stuck off a train in the middle of nowhere because all he brought with him was this legislative fare, and you can't go back and take that away from him. But it really is a tort case. It's not a simple case here. Here, these folks, they never changed, to your point, Judge Niemeyer, about the permit with the change. These tenants had no idea of the statute. There's no reliance. There's no change in conduct. They paid these fees and moved on. So they didn't do anything differently. Their only claim is that we've overpaid because we think the law now says you shouldn't charge these fees. And the legislature's now said we never intended to prohibit those fees, so there was never any injury as the legislature determined it. But this is a purely legislative right that the court is free to take away after the fact. Is that it? Thank you. Thank you, Your Honor.
Thank you. Mr. McGinnis, do you have a little rebuttal?
Thank you, Judge. I want to take this time to address, Judge Wynn noted this was a new one for me in terms of North Carolina law, and it is not the case that there is a delineation between statutory and common law such that one vests at injury pursuant to the Constitution and one requires a judgment. And let's start with Dyer, because that's the case he just said establishes the principle.
You're saying before Dyer, if it's clear before Dyer, there's no such thing.
I think that's what my friend said. He said Dyer establishes it. And no North Carolina court has ever found that an injured party's claim is retroactively stripped. All of the cases cited that required a judgment did not involve an injury. It has literally never happened. What Dyer says, so it's a short opinion. Check my math. They like the first clause of the end of this opinion that says, if the penalty had been reduced to judgment. Then there's an or had been given to the injured party in the nature of liquidated damages, the case would be essentially different. Dyer identifies that there are different paths. You may need a judgment if you do not get the protection of the Open Courts Clause from an injury, or the passage of time. Statute of limitations is a creation of statute. You do not need a judgment for that to be a vested right. We provided the court with additional cases that were pure statutory creations: train tickets, dog bites, laws of corporation. There were no judgments in those cases. The legislature did not take it away in those instances. The courts found, the North Carolina Supreme Court found that those statutory claims vested separate and apart from a judgment.
They said in there, you had this fellow here saying, this law says you can get $100 from the commissions. Commissions are pretty political folks, and they got the legislature to get rid of that $100 fee, and the Supreme Court said, yeah, you don't have to pay it. You hadn't vested until you actually established that you can get that fee, I guess the judgment of it.
Not an injury case.
You think the distinction is that's a penalty as opposed to an injury of some
Absolutely. The Open Courts Clause doesn't protect penalties. It says every person for an injury done him in his lands, goods, person, or reputation shall have remedy. And Dyer says, if the penalty had been reduced to judgment, that's their argument, or had been given to the injured party in the nature of liquidated damages. So if there was an injured party, there's no injured party in the person, a private attorney general action regarding the publication of who paid their taxes and how much they paid. There was no injured party. They don't get protection of the Open Courts Clause. That's why they don't discuss the Open Courts Clause. That's why Dyer's not discussed in Forrest, which establishes what the term injury means.
But Forrest was only a standing case, wasn't it?
It's a standing case, and the way they determined what the law of standing is in North Carolina is what the term injury means in the open courts provision.
Isn't that a cart before the horse argument?
A little bit. It's a two-part argument. First, we've got to establish that injuries vest at the time of action. There's a long list of case law. Just because there are other cases that required a judgment where there was no injury doesn't mean that there isn't hundreds of years of cases in which there was an injury and that vested. Then we need to establish, were these claims injured? Well, the payment of the unlawful fees is an easy one. That's economic damages. And then what the court said in Forrest is if you have an infringement of your legal right, we think that overrules some of the cases, but it may well be that your legal right requires a personal right, such that private attorney generals like actions like Dyer or some of the cases that don't involve injury aren't impacted by Forrest.
You know, I know it's important to your side to talk about injury, but really what we're talking about is the reimbursement of costs. This is an ejectment action, and the 2009 statute talks about certain filing fees that can be collected and certain things that can't. And it's not totally clear if you're just reading that statute whether ejectment, court costs for filing an ejectment and paying the sheriff is compensable. But it strikes me a little awkward that we're calling the obligation to pay a filing fee injury.
So
in other words, it's a contractual obligation, and the legislature apparently took it away, but then restored the reimbursement of costs. And that's all it is. It's just a reimbursement of costs for the process. As a matter of fact, if you're talking about fairness, that's pretty fundamental, that if somebody requires an ejectment process, that is part of the default, they pay the cost of filing fee. And so every time you talk about injury, I'm trying to figure out how are they injured? I mean, they had the legal obligation to pay something. And,
they didn't.
And it was, according to your colleague, it's unclear what that obligation was on the 2009 statute. And so that's why he argues that the 2018 is clarifying.
So let me address let me make two quick points.
I didn't appreciate fully whether it's clarifying or substantive, because I've always believed that you can make substantive changes retroactive as long as you make it clear. The Supreme Court's talked about that many times. The presumption is prospective. but unless a legislator says otherwise. And then the only question is the constitutionality of such a thing. But I guess both of you are not really going that far.
Let me respond quickly, because this is something that came up in the Suarez case, because we heard these are our costs, they're not even fees. There's a case called State v. Webb, which essentially says costs and fees are two sides of the same coin. The court has costs and they charge a fee. That is a cost for the landlord, and they charge a fee to the tenant who is charged a fee. Fees and costs are two sides of the same coin. And they're not obligated to pay them because the contract wouldn't have allowed them to do it. And nothing about this statute in 2009 prohibited landlords from using the court process to recover eligible court costs, which they would otherwise be eligible to recover. What the contract, or what the statute addressed, was the ability to charge them simply for filing outside of the court process. And it wasn't allowed before. And it was allowed after 2018.
It was a filing fee that had to be filed for an ejectment procedure and a cost to pay the sheriff to accomplish the ejectment.
It is. And so they suffered costs and they assessed fees. And you could attempt to recover those through the court process. Filing fees are actually not recoverable under North Carolina law. Sheriff fees are. And so these costs and fees are two sides of the same coin. This is something that came up in Suarez. And I think that's, if you find that there was a payment prior to the 2018 amendment of these fees, they suffered monetary harm, they suffered an injury, that's protected by the Open Courts Clause. There's no artificial...
They didn't suffer anything until it was awarded against them. They paid it, but in other words...
so it was never awarded against them.
It was imposed as part of the collection costs.
This wasn't through the court process. There were no costs assessed. What happened was there was a dismissal. What was happened is they were charged, and that's been alleged and not in dispute at a judgment in the pleading stage. They were charged, they demanded that they be paid, and it was an unlawful fee. That's an injury. We do not have a distinction between statutory and common law that is right down the line. Statutory, you must get a judgment. The case law just doesn't support that. There's 6 or 7 cases that we provided just an oral argument that involve statutory rights that vest without a judgment. There's multiple paths here. One of them is injury. That's the one that's protected by the North Carolina Constitution. And although Forrest is a standing case, it defines exactly what injury is. And according to Forrest, it doesn't mean that it could be that there are people who have retroactive effect. You can have retroactive statutes. And as applied, it's possible that this statute, as applied to somebody else, could have retroactive effect. But as to Ms. Bass and Ms. Wiggins, who suffered a harm, they would be the first individuals in North Carolina jurisprudence to have a claim stripped where they suffered an injury. Thank you.
Dyer has been around for quite a bit, hasn't it?
Dyer has been around, and because it's a penalty case, it limits itself. It's a private attorney general action. They were very common at the time. It doesn't have anything to do with injury. And in fact, the Williams case, which talks about common law principles, it doesn't say it has to be a common law claim. There's nothing in there that says this is similar to leaving yourself at a train. It just says there's common law principles, and it distinguishes Dyer because it says it's not a penalty case. Dyer's a penalty case, and if it only stands for the fact that on a private attorney general action you need a judgment, then maybe it hasn't been overruled. But they're stated.
Make the point that that's a case that's 122 years old. It'd be nice for the Supreme Court of North Carolina. Once again, I must say, they ought to allow these cases to be certified. But
And if it's still...
been spoken on that, and falling on deaf ears there. If they don't want to do it, we'll do it for them.
We will do what we can with the legislature, Judge.
All right, thank you. You've probably heard as our custom and practice, and you probably know, it's actually unique in the country, I think, for us to come down and shake hands with counsel following each case. We're observing our protocol on COVID still, and we hope we can lift that soon. But at this point, our greetings to you from the bench, and thank you for your arguments. We'll have to do. We welcome you back. Come back next time. We'll shake your hands. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, we'll take a short All right, be seated, please. All right, the next case we'll hear is United States versus Davis, and Ms. Herzog, we'll hear from you first.
Yes, Your Honor, thank you.
This is another 924C case, isn't it?
It is, Your Honor.
Probably our 934th.
Fair enough. Well, hopefully I'll try to keep it interesting. May it please the court, my name is Allie Herzog, and I represent the appellant, Mr. Davis. As Your Honor just noted, this case is about whether Mr. Davis's 924C conviction for the use of a destructive device in the commission of a crime of violence is supported by a valid predicate crime of violence. In this case, the predicate crime is 844F arson. Under the broad reading of 844F arson that the government employed to convict Mr. Davis, it is not a crime of violence for two reasons. First, it can be committed against the defendant's wholly owned property, and second, it can be committed recklessly. Either reason gives this court a basis to hold that it is not a crime of violence and vacate Mr. Davis's 924C conviction.
Well, we recently got affirmed by the Supreme Court in a case called Taylor, and the argument made before the Supreme Court was there were three scenarios. Two involved attempt or use of violence. The third scenario did not. Does that logic apply to this case if you use the categorical approach? If there is a scenario that does not involve violence, such as burn your own house down, wouldn't that solve this problem here?
Yes, Your Honor, indeed it does. Under the categorical approach, if there is any way that the crime can be committed without meeting the definition of a crime of violence, which of course is the use of physical force against the person or property of another, then the crime of conviction will not meet the definition and is not a crime of violence.
But he
So in
still
this-
could be charged with arson under another statute.
Yes, you still could be charged with arson under another statute, although I will note that another panel of this court in Wilder recently held that the similar 844I arson statute is also not a crime of violence for a similar reason, that it can be committed against the
The
defendant's
offensive
wholly owned
language
property.
here is the used by, I gather.
Yes, Your Honor, the key language here is used by.
In other words, he could still own it, and it could be used by the government, and then it wouldn't violate the arson statute.
That's exactly right, Your Honor. And in fact, that is the situation that arose in Mr. Davis's own case. In that case, the qualifying organization that was using the property was a state agency, the Virginia Housing Development Association. And this court held that that agency was using the property because it was accomplishing its statutory function of aiding low-income families in obtaining a decent place to live by subsidizing the rent of a private tenant who was renting that townhouse from a private property owner. And in that case, the qualifying organization that was using the property was a state agency, but it was, of course, the property of the owner of the property, arguably the tenant of the property, but not of the state agency that was using it. And so Mr. Davis's case gives a pretty clear example of a situation in which the statute applies to situations that fall outside the definition of crime of violence.
All right, so that's about it, isn't it?
Yes, Your Honor, I would pretty much say so.
Questions about that? All right, why don't we hear from the government and see why used by doesn't cause a problem?
Good morning, Your Honor. May it please the court. Aidan Grano-Mickelson for the government. I anticipate I have a bit of an uphill argument with you to convince you that used by does fall within the meaning of a crime of violence, but hopefully I can do that. I think the defendant's reading of the statute puts too little emphasis on the practicalities of what it would mean to be possessed by or used by an organization that receives federal financial aid. I struggle to think of a realistic...
Used by goes even beyond that. Used by, I mean, they could be used in the living room to interrogate witnesses in the neighborhood about drug dealing. And then all of a sudden he leaves the house, he lets the government use it, and then burns it down because evidence, there'll be evidence in his own place. I mean, there's just, it's used by is problematic, it seems to me.
It's certainly difficult, Your Honor, but I would say even in that scenario, there are federal officers with federal property and federal personnel.
He's burning his own property, and it's supposed to be burning the property of another.
But the property at that point, if it reaches then the property that's being used by the government, it threatens the property of the government as well. It threatens the personnel of the government. It threatens
they
the
left.
property.
5 minutes later, he burns it down because they're going to come back with a warrant maybe or something. I don't know. There's just so many types of situations where the government can be using somebody else's property.
Your Honor, I disagree that that would fall within the reach of the used by statute because
What limits it?
I think if I were to come to the court and argue that the government was still using the property after it had already departed, this court would correctly chastise me for stretching the
How about if
statutory.
they went to lunch? We're going to come back in the afternoon. I mean, you know, I didn't see any limitations on the word used by.
Your Honor, my argument for used by comes from Leocal itself, which is that the government has to be actively employing the property, or in this case, the organization, and that kind of active employment of a piece of property necessarily means that when someone is committing malicious arson that threatens that property, they are also doing so against the property or the persons of the organization that is actively using the property at that time.
Well, the maliciousness could be coming from getting insurance coverage. I mean, that's arson too, isn't it? If you burn down your own property, and but not under this, not under 844F, 1994 version.
Yes, under the 1994 version, which is different than the modern version of 844F, it does include the additional used by language. And my argument would still be, well, the organization or the government is actively using a piece of property. The malicious arson, which necessarily requires the mental state that you know it's going to be substantially likely to threaten the piece of property while it's being actively employed by an organization or by the government, at that point.
Does the government actually have a lease?
It does not require to have a lease under the 844 version of the statute, or under the 1994 version of the statute, Your Honor. But I don't think property of another within the meaning of 924C is limited exclusively to ownership or leaseholds. There's no indication from the statutory text or from the legislative history that Congress intended to impose that kind of technical property rights analysis.
Well, it looks like the statute would require the burning of a property of another with the idea of depriving the other of a property interest. Doesn't it use the property of another?
It's the person or property of another, yes, Your Honor.
Well, yeah, the person's not here. The property of another suggests that it's depriving the other of a property interest. And one way to argue, I suppose, is that, I don't know about the used by. Used by gives you a property interest.
I think, Your Honor, if Congress had intended property of another to be ownership interest or leasehold interest, it could have said that. I mean, it used the words owned by or leased by in 844 itself, and if it wanted to use that in 924C, it could, but it used a much broader phrase of property of another, which I think encompasses a broader set of relationships. In the Fourth Amendment context, for example, we recognize that individuals have privacy interests in merely possessing an item, even if they have no ownership title to it. And so when we think of people's relationships to property, I think that spans broader than technical property ownership or even leasehold interests. So I would argue that under 924C, Congress did not cabin its meaning exclusively to technical property ownership under state law, for example, but rather...
Isn't the real purpose of this 924C that the government's seeking to impose a greater penalty than he would have received under the other statute?
Yes, Your Honor, it is a separate offense, so the 924C charges are in addition to the underlying predicate offenses, and Congress was very clear that when things like firearms or explosive devices are used in this context, the harm to society and the potential harm to individuals is significantly higher. So when Congress enacted an entirely separate statute to capture this conduct, I think it's fair to assume that in situations like this one, where an individual uses an explosive device, at property that's being used by an organizational entity, that the risk to individuals, the risk to that property is substantially higher. And I have not seen a single case in the 844F context, in which a person committed 844F arson against property that was solely owned by themselves with no organization or institutional entity having any relationship to that property. I think it's just beyond what was charged under that statute, under the earlier 1944 version.
The use here is the Virginia Housing Authority has used the property by providing financial assistance to the tenant. And you say that is actively employing some activity on the property and it defeats, I guess, the ownership of it?
This court said that it was actively using the property in the 90s when it addressed Mr. Davis's case.
Statutory interpretation are you using to read that into the statute is what I want to know.
So I think, Your Honor, by giving subsidized affordable housing vouchers and additional payments, the state agency, this court concluded, was using federal funds, accomplishing its purpose, and using the property to provide affordable housing to individuals who qualified under Section 8.
Does that mean every bank is using property when the bank is financing a mortgage?
Your Honor, I think technically, if we're going by a property theory, a bank does own a property interest in a home when they have a mortgage on it. They own a superior lien.
You put on an FHA assistant loan on it, you're saying you don't really own your house for this purpose here.
I would not say that the bank is using the property in the same way that the VD.
It's the same thing if you're providing financial assistance, or if you just, as Judge Niemeyer alluded to, a mortgage, but you certainly have government assisted type mortgages.
Or guarantees?
Guarantees on it. So how does that work in this? You see what the problem is with this? I mean, in terms of where we go with it, and we're kind of playing around this issue here, but sometimes you have to go directly and deal with something because we can create some serious problems.
I understand the court's concern, Your Honor. I do think that this court, in Mr. Davis's case, was very specific that it wasn't just the fact that there were federal funds involved, but that it was an ongoing program where the Virginia State Agency was continually providing vouchers to this person. It was actively employing this property to accomplish its statutory purposes and to use those federal funds. So I don't think it extends as broad as the court might be concerned. I'm certainly not here to argue that this is an easy case. It's certainly a difficult one. But I do think that where this court drew the line at active employment does provide some context that in the real world, when an individual commits malicious arson against property that's being actively employed by or used by an organization, they have necessarily threatened the property or the personnel of that organization during that active employment.
Okay, I think we understand.
Thank you, Your Honor.
Any rebuttal? Ms. Herzog?
Yes, Your Honor, I'll be brief. I just wanted to point the court to a due process decision that I think sheds some light on an easy place to draw this line. In Richardson versus Town of Eastover, which is 922 F. 2nd, 1152, this court explained that at a very minimum, a revocable at will license to use a property creates no property interest whatsoever in the holder. So even if there were some difficult questions, as opposing counsel alludes to, regarding leases or mortgages, those difficult questions are simply not raised in this case because this case requires mere use of a property, which does not convert the property into the property of the user. Unless the court has any further questions.
Okay, well, thank you. I notice you're court appointed, and I'd like to recognize that service. Of course, it's very important and appreciate it, and thank you for providing that to us.
Thank you, Your Honor.
We'll normally come down and greet counsel, but we're still observing the COVID protocols, and so we'll forego that. But the next time you come, I hope we can assure you that we'll shake hands with you after argument. Will you please adjourn court for the day?